So the big headline today on 10 p.m. is that with the rise of digital platforms and the rapid spread of content, governments worldwide are grappling with how exactly to regulate online discourse without infringing on fundamental rights. It's an issue which we on Mirror Now have been focusing on for the past several weeks now. In India, this tension has played out in a crucial verdict by the Bombay High Court, which has challenged the government's attempt to police online content in the name of fact-checking. The court has invalidated provisions that allowed the central government to establish a fact-check unit tasked with removing online content deemed fake or misleading, calling them unconstitutional. So essentially, these are the three grounds in which the Bombay High Court today decided that the fact-check unit is violative of the Constitution. Specifically, it violates Article 14 of the Constitution, which is the right to equality. It violates Article 19, which is the right to freedom of speech and expression. And more specifically, it violates Article 19(1)(g), which is the freedom to the right and the right to practice one's profession. These are three specific articles of the Indian Constitution which have been deemed violated by the fact-checking unit here. Now, the court further emphasized that terms like false, fake, and misleading were vague and lacked clear definitions, therefore making them problematic under the law of the IT Act. Now, this ruling has come today after a long legal journey, which the case initially saw a split verdict earlier this year in the Bombay High Court. First, you had Justice Gautam Patel, who struck down the rules and declared this fact-checking unit to be anti-constitutional. Then you had Justice Neelam Gokhale, who gave this the thumbs up, saying that these rules should be upheld, which is why we are looking at a split verdict, a 1:1 verdict. Justice A.S. Chandorkar was brought in as a tiebreaker judge, and he today delivered the decisive ruling, which then strikes down the rules in the Bombay High Court. Now, today, this, of course, came from the High Court, but it has repercussions in the Supreme Court as well. How? Let's explain. The controversy began with the centre notifying the formation of a fact-checking unit in March this year. But then just a day later, the Supreme Court did step in and state the notification, stating that the issue dealt with the core values of freedom of speech and expression, as we discussed in and key tenets of the Constitution, which have now been turned to be violative. And then the government should have waited for the final verdict from the Bombay High Court before proceeding. Now that the Bombay High Court has given its final verdict, the big question is what happens next? Will the government challenge the ruling in the Supreme Court, or will it seek to amend the rules once again to make it on par with what the courts want? I'm being joined first of all by Mr. Apar Gupta, senior advocate and co-founder of Internet Freedom Foundation. Apar Gupta, thank you so much for joining us on Mirror Now. My first question is, how big a win is this for you and for everyone else who have been campaigning for the cause of digital freedom?
Thank you so much for having me here. Firstly, I'd just like to correct, I'm a practicing lawyer. I'm not a senior advocate. And just like to emphasize that today's verdict by the Bombay High Court is a victory for every Indian. It's not only there for the people who are either journalists or the people who use the internet, because it restates the fundamental rights under the Constitution of India and the liberty all of us enjoy in receiving information without the government determining what should be reported on it as per its own subjective criteria. Here, credit goes to the Bombay High Court, the petitioners who approached it, and the legal teams who were there. And its significance is far-reaching because I think the IT rules under which this fact-checking power was indeed made provided the government such a wide ambit to censor anything which they thought was fake, false, or misleading without defining what is fake, what is false, and what is misleading. So whenever any kind of restriction is made by the government in any kind of law, there needs to be precision, especially when it is looking to restrict anybody's fundamental rights. Now, this precision is lacking, and when precision and definition is not provided in a law, it essentially means the government has a subjective power or an arbitrary power. The second thing is, this power was only with respect to the central government by itself determining anything which is expressed with regard to the central government. which was phrased as business of the central government. What this means is that the fact check unit, notified by the central government, determines by itself what is reported on the central government is fake, false, or misleading. This means the government was acting like a judge in its own case and was not complying with any standard of natural justice. So
Okay.
this is why I think this judgment is a far-reaching verdict and correctly, I think so, expresses the constitutional intent for us to enjoy democratic discourse.
So, Apar Gupta, as you pointed out, one of the key provisions in the act which was highlighted today in the Bombay High Court when it came with its tiebreaker verdict was this vagueness over the terms of fake, false and misleading. It didn't specify as to what actually the government meant when it referred to these terms. Do you feel this vagueness was by design so that the government had a larger window to try and pigeonhole anything which it felt was critical and which it felt was too inconvenient of a truth under the terms of fake and misleading and perhaps even false?
So I think one needs to understand that even if government regulation does want to, let's say, the stated objective is to curb disinformation online. Okay, all of us would agree that disinformation is a big threat and needs to be countered, and authentic information needs to be put out. The way to go about it is that you need to increase media literacy. The government can essentially put out its version, which it does through the Press Information Bureau. And it also quite often contests any kind of legal report which is put out. The reason I'm saying this is that the first step any government should take is not to make a censorial law, but to put out its version with all the money, all the government departments, in fact, even an information service, which is a specialized cadre, and it already has it. Okay. Only after that comes the question of it creating a censorship power. Now, the censorship power, which you are, and the question you posed me, has the government with a deliberate, malified intent created this power? I would not be able to comment on that. However, I will say that on its very face, this power is arbitrary. And the way it would have been exercised, and thankfully the court stepped in, they stayed it. But here it's much more important that either through malifieds or either through incompetence, even an incompetent king is very destructive for any kind of republic. And we need a precision in laws whenever there is any restriction of liberty. Because, for instance, if this telecast is not liked by a union minister, the fact check unit can say, oh, there are two sentences which are wrong in this broadcast, which are misleading. And what does misleading mean?
Exactly. Exactly. And on that basis, if there are two sentences which are deemed to conform to the term misleading, those can be grounds for this entire broadcast to be taken. And that was one of the key grounds on which the arguments against this petition were fought. Now, my next question, Mr. Apar Gupta, is that if not the government, whose job should it be to fact-check data that is put on? Because I'm sure as someone who's involved with internet freedom, we are dealing with the misinformation pandemic on a daily basis here. Do we need fact-checkers? And if so, whose job should it be to fact-check and verify or authenticate the information that we access on digital platforms?
So forgive me for being an idealist and a big fan of journalists here. Because a lot of people today, neither they like lawyers like me or people who do activism, but they also don't like journalists. I think journalists fare a little better than lawyers. But leaving jest aside, let me just say that fact-checking has always been an essential component of the press. Here, digital broadcasters, news platforms, newspapers have always been people who have gathered local reports and have then made them available to a larger audience. They have often done investigative reporting, which has brought new facts to light in the public domain. The mastheads of so many newspapers use words such as courage, belief, power, questioning power, etc., etc. So I think having a healthy, flourishing press is the best source of us as the public, not only the government. We can't blame the government for everything. I think a large amount of the responsibility does rest on ordinary Indians in terms of their lack of distinction between what they call today as content and journalism. So I think supporting journalists, supporting platforms, becoming a subscriber, getting a newspaper is actually one of the principal functions which needs to be played. So there's a large part of media literacy here involved. I think the fact checking needs to be done at a social level. The government does have a job here, but the government's primary job should be in encouraging this ecosystem to flourish, knowing, and this comes with the knowledge that governments quite often may, with the best intent, still want to control what's written about them. You may like this government, okay, I may not like this government, I may like another government, but I know for a fact that even that government will like reports which are flattering it, which are commending it, rather than those which are questioning and criticizing it.
Okay, Mr. Gupta, thank you for upholding the faith you have in my profession. May I just say it is mutually reciprocated as well. My final question, Mr. Gupta, very quickly, do you anticipate this legal war to go on in the Supreme Court as well? Because the Supreme Court had earlier said that it was waiting to see how the Bombay High Court views this entire matter before proceeding. Do you expect the government to move an appeal in the Supreme Court?
So I would like to frame this as a military contest. I would hope that the government, given that it recognizes that there has been a certain error which has been committed by it, which also re-emphasizes public faith that when there are, no government is perfect, there are mistakes which are always made. If a court does hold a provision to be unconstitutional, I think it is in the best of spirit for the government to conduct a legal review before even approaching a challenge, rather than just mechanically approaching the Supreme Court. And also the Supreme Court has quite often expressed that the government, not only this government, but governments usually are in the habit of mechanically filing appeals. So I hope there is some introspection, there is a legal review and study of this judgment, because I believe it is a sound judgment. I say that without being partisan to the result.
Okay. Well said, Appa Gupta. Thank you so much for joining us on Mirror Now and taking out the time to break down this very landmark verdict, as you pointed out to our viewers. Let's now move in to my panel of guests who's joining me to take this discussion forward. We have Anant Nath, President of the Editors Guild of India. We have Advocate Vera Gupta, cyber law expert as well. And I'm also hoping to be joined by Karun Anandi, senior lawyer from the Supreme Court as well. Anant Nath, I'll start with you, since the Editors Guild was one of the key petitioners in this case in the Bombay High Court. So first of all, congratulations for having this very monumental victory in the court. I would like to begin with asking you, what were the key provisions in the IT Act, or at least in the setting up of this fact-check unit, that was of such concern to the Editors Guild of India?
Thank you. So I think the biggest concern was that government had given itself the sole authority to decide what is fake, misleading, false about its own affairs, and taken the power to identify such content and then direct social media intermediaries to remove content which, in their opinion, was fake or misleading. Very vague words, very broadly defined words. So there was vagueness in formulation in what is fake and misleading. Secondly, they had given absolute powers to themselves without any oversight, without any checks and balance. So it was the government assuming entire power onto itself. So this was nothing less than censorship, because the job of any media is to question the government, is to question government's narrative, even factual, reports. And a mere act of just questioning a government reportage, maybe giving an alternative view, would label your content as either fake, misleading, or false, and therefore giving the government powers to bring down your content. So this was censorship at its worst form. I mean, there is no other word for it, and that was the biggest concern, which was at the center of our petition.
All right. Advocate Vera Gupta, cyber law expert, thank you for joining us on Mirror Now. Now, the concern in this law which Anant Nath had raised, isn't there a fundamental contradiction when you expect the government to be the arbitrator of what is fact and what is false and what is misleading? The same government which will have it in its interest to ensure the truth which shows it, or details or facts or reports which show it in a negative light, which compromise with its integrity in the society will be detrimental to its interests. Isn't there a basic conflict of interest that the government is deciding to be a player and an umpire on the cricket field at the same time?
Ritangshu, I agree with Apar, I agree with Anant. But I feel that we as a nation are suffering from virus of deflecting the main issue. I feel that this judgment is concentrating only a small aspect, leaving the main things which are very crucial for right to equality, that is Article 14, and right to life, that is under Article 21. Now, first, I don't agree with this tie-breaker judgment. When two judges, equal judges, are differing from the main issue, then why should it go to the third judge who is equivalent to all other two judges? It should go to the three judges bench. That is my, I think, understanding, and it should go to the three judges bench. That is one thing. Now, let us come to the main issue of Article 14, 19, and 21. Okay. Now, Kangana Ranaut movie is held before the censor board, and there is the same government. It is not being released. Now, if it is in the OTT, same could have been released without any censor or without any objection. So, Article 14 equally applied to the conventional media and the digital media. So, if the court says that Article 14 is there, so it is a vice versa, because the conventional print media and the conventional other media are regulated by the various rules, laws, and wherein even the district magistrate is a capable and competent officer to take many actions. So, Article 14 does not apply here. That is the one thing. Now, secondly, this fake news menace is the biggest menace in the digital media, social media, and this is impacting right to life of millions of the persons. So, state government is duty bound to protect the citizens from the menace of the fake news, but instead of taking the right action as mandated by the constitution and law, government is concentrating on this small object, and I will say that there is a Noora Kushti between the government and the tech giants, wherein civil society is due to mistake or whatsoever may be the reason, is part of this whole game, because tech giants, these private players, whether it is a Meta, Google or the Twitter, they are adjudicating the matters. They are deciding by their bots or other things that what matter can be there, who will operate, against whom action can be taken. We have seen this in the US elections also. Big tech giants have taken action against the Trump or not taking any action against them. So, if the private players can take the action, why cannot the government take the action? That is the first point. Now, second point is this IT intermediary rules. Genesis goes to the 2011 rules, which were first implemented in 2013-14 by the Delhi High Court in K. N. Govindacharya matter. Now, those rules are yet not enforced, and I feel that action needs to be taken on regulating the AI, number one. Secondly, data protection law is passed, but data protection rules are not notified, so there is a data breach.
No.
Thirdly,
Advocate
privacy
Vera,
breach
Gupta,
by these
with
tech
all due
giants.
respect,
And
we have had these conversations,
all the political
and
parties
these have been
running
very illuminating conversations we have had on big tech and AI, but I feel we are slightly digressing from the topic at this point, which is why I would like to cut you in at this point. You mentioned the example of Kangana Ranaut's movie Emergency being delayed by the censor board as an example of how censorship works in a TV medium. I'm not sure the point holds, because the co-producer of the film very recently moved the court saying that, you know, it's under the direction of the ruling BJP that the censor board has stalled the movie because the BJP is afraid of the electoral repercussions in Haryana. So once again, even if there is a movie which is seen to be pro-establishment, we still see the establishment taking control as to whether to release the movie or when to release the movie. However, you made a larger point, which is then I would like to bring back to Anant Nath here. Mr. Nath, now the contention being made by Advocate Gupta is that when we already have existing mechanisms to monitor and regulate electronic media, to regulate print media, surely there is a need to bring regulation of the digital media also at par with what we have with other media, because otherwise we see digital media as this untamed, unchecked beast, which, yes, in terms of its reach, in terms of its efficiency, in terms of its speed is unparalleled, but at the same time can also be equally devastating and lethal given the fact that there are no checks and balances on this entire beast right now.
Umkar, I think that's, of course, a very larger question about the problem of fake news on social media. But just to sort of center the point again, because I think what Advocate Gupta was saying went into multiple directions. The problem here was government's
Yeah.
amendment was not about fake information or misinformation in general. It was primarily about what they thought was misinformation or fake, misleading about their affairs. And the reason why Justice Patel and Justice Chandukar has has agreed to Article 14 being invoked in, because there is, it's against the right to equality, because government was putting itself at a higher pedestal than all other entities and saying they merit a special treatment where they are the judge and the final arbiter and the victim in their own affairs. That's where the entire thing sort of centered around. Vis-a-vis the larger question of misinformation in the online space, I mean, IT rules itself have put in place a three-tier mechanism, which is also under challenge in Madras and Karnataka High Court. And there again, the problem is that the three-tier mechanism, the first two being self-regulatory or self-regulatory by the organization concerned or by a self-regulatory association. The third and the ultimate tier is still government mandated, government constituted, where again the government has the sole authority to decide what is problematic or not. Now again, in both IT rules 2021 itself and the amendment passed thereafter, the government had taken the entire power to decide what is right or what is wrong and giving itself powers to sort of remove that content. We're against that. I mean, surely there is a problem, but that problem needs a self-regulatory framework where government can be a part of it. It can't be a majority voice. It definitely can't be a sole voice, which is where the problem with the current framework is, that government is not just the majority voice, it is the sole voice. So a new mechanism has to be built in. I mean, sure, there can be a self-regulatory mechanism, but government voices should be invited, but they should be a minority voice, and they shouldn't have overwhelming influence on, on what the decision is being taken.
Fair enough. So the government should not be the sole arbitrator. It should be part of a team of arbitrators, or at least an ombudsman of arbitrators, where, as you say, Mr. Anant Nath, that the government should be a minority voice, if at all a voice at will. Let me bring in Advocate Vera Gupta on that. Advocate Gupta, you mentioned earlier the epidemic or the problem coming in from fake news. Now, the problem is, it's been seen empirically that political parties are among the biggest benefactors of fake news, which is why we have IT cells. I'm not naming any political party, because I think that today's days, whoever would have got the first move and advantage, that's been erased now. All political parties have an IT cell, all political parties have a dirty trick department, and they're sometimes the worst offenders when it comes to trying to manipulate news and trying to distort news in order to achieve their political ends here. Now, ultimately, any of these political parties will form a government, whether it be today or tomorrow. So is there not a basic fundamental contradiction in giving power to the very authority which benefits the most from harnessing fake news in a particular direction?
No, I think Anant has rightly said that government is not taking concrete action against the fake news, and they are trying to control those voices who may be criticizing or who may be having some opinion against the government. So that's what I'm saying, that government is only concentrating a small aspects so that they may not have to enforce the IT rules. Now, let me again come back to the Article 14, that if the tech giants, whether the Facebook or the Twitter or other intermediary players, are carrying their own private fact check and they are taking action against the objectionable content without passing any adjudication order, so whether the government should not have authority which has the sovereign authority as per the constitution. So nobody is saying against the private players. Okay. They can block the content, they can decide the priority of the content, they can remove the content, and they can block the content. So that is the one aspect. Now I am coming to the second aspect, that is the constitutional aspect. As per the 7th schedule of the Constitution, law and order comes within the domain of the state government. Unfortunately, in digital India, state government have no say on these matters which are primarily coming within the domain of the state government. So on all these digital matter, only the IT ministry, MeitY are taking the action. That is something very unfortunate. And as per the law and order, these things should also be consulted by the state government. Now, the third point is, we are talking about the civil action of blocking or removing or modifying the content, but we are forgetting about the criminal action, where a SHO or inspector for objectionable content can take the action and lodge the FIR, or district authorities can discontinue with the internet, or the central government can even block that app or intermediary. So we have to see that government has the much broader power, and we have to see that what is the main concern and how should we control the menace of the fake news. And I think government is not taking any action in that direction.
Okay. So from one advocate, let me get in another advocate's view on the panel at this point. Karuna Nandi, senior Supreme Court advocate, is joining us. Ms. Nandi, the argument being made by Advocate Vera Gupta is that if you're looking at big tech, for instance, Meta or X, to try and also regulate fake news which is being fed on its platforms, and we are giving them the freedom to try and use their discretion in order to how to filter out fake news, why should this opportunity not be given to the government, which at the end of the day is responsible for law and order in the country? And if it feels that there is some fake news or some misleading information which is a threat to law and order, it has every right to step in and classify it as misleading or inaccurate.
Look, I'm not sure that that's what the gentleman before me is saying. However, there is a distinction between what, say, Twitter is doing with fake news or misleading information, and what this particular provision in the IT rules seeks to do. What Twitter is doing, for instance, is asking for community notes, right? Now, community notes is a sort of crowdsourced manner in which if something looks fake, then a number of people say that, look, this is inaccurate, this is the actual thing, so it doesn't get censored. What the central government was attempting to propose, however, in Rule 3 was to say that, and this is something that they issued in 2023, right, is that they said that in respect of any business of the central government, if fake news is identified or false or misleading, then a fact check unit of the central government itself, as the ministry would then be able to have control over it, right? Now, the thing is that what is the essence of a democracy? The essence of a democracy, and what is the social contract that we have with our state? We say that, look, we are going to give up these rights so that you can govern on our behalf in these ways. Now, if the central government is going to say that I am going to govern on your behalf and you can't say anything bad about me, right? Then this breaks that social contract in very, very important ways. Because then that means that we don't know what's going on. There is no critique of what government is saying. All is hunky-dory and rosy. In some ways, this only ramps up what is already happening, because taxpayers' money is being spent by this government, and really crores and crores of taxpayers' money, to sell government back to us as being, and not to sell government really, to sell the BJP back to us as being a positive force. So we're paying for our own indoctrination in that sense. Now we would be paying for our own, to be kept in the dark. And that obviously is a major problem. So I'm pleased to say that Justice Gautam Patel's judgment was excellent. And there was a split verdict on the 31st of January. And now on the 20th of September, the umpire judge has come and found in favor of Kunal Kamra and the Editors Guild. And this is, here we are, a step forward. I am going to say one thing, though, is that government must act constitutionally at the first instance. And when I say government, I mean the state government and I mean the central government. Here, very much the central government. Why? Because the ambit of the court in either reading down or striking down legislation or rules is very limited, right? So in court, we will argue over what the meaning of one word is, say. Does and mean or? You know? A huge constitutional bench case was decided on whether and or were meant the same thing in a statute, right? Whereas when a rule is just inserted by someone sitting in government and writing it down and saying we should have this with layers of approval, then that can be done. You can have like a whole statute. The statute should never be drafted in a short time, but a whole statute drafted in 3 days. So the government must act constitutionally in the first instance to prevent this sort of thing. And this is egg in the face of the government.
So my final question to you, Ms. Nandi, again, before we wrap up this discussion, since you are also an advocate with the Supreme Court, a senior one at that, this is a judgment which is coming from the High Court, but it has repercussions in the Supreme Court as well, because the Apex Court had earlier said that it will wait for how the Bombay High Court views this before coming up with its own observations and its own verdict on what it feels about, of course, the fact-checking unit here. Do you anticipate the government now moving the Supreme Court to appeal against the Bombay High Court's verdict? And do you feel that this is a protracted legal battle which is now just entering the next phase instead of being concluded as a comprehensive victory in favor of free digital speech?
I think the government should not challenge this because it would be the wrong thing to do. I think the government, I hope, sees the light when it reads Justice Gautam Patel's judgment in particular. I fear, however, that this will not be the case and that the government will appeal. So yes, this will be, I'm pretty sure this is likely to be challenged in the Supreme Court, and we will see what the Supreme Court says.
Well, that is, of course, as Ms. Nandi pointed out, a debate and discussion for another day based on a verdict which comes another day. But for now, it does come across as at least a landmark verdict by the Bombay High Court. The fact-checking unit has failed the court check, which means for now at least as the Editors Guild of India and as Kunal Kamra may say, this is a big win for free speech. Anant Nath, President of the Editors Guild, Advocate Vera Gupta, and also Ms. Karuna Nandi, Senior Supreme Court Advocate. Thank you so much for joining us on this very illuminating discussion on Beyond the Headline. It's time for a short break. More news and updates continue the other side. Stay tuned to Mirror Now.